Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Kandt, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Kandt, your trusted attorney advisors in safeguarding what matters most. Welcome to another episode of the Smart Legacy Podcast. I'm your host, Glenn Stockton. I'm managing attorney for the law firm of Stockton and Kandt, located in Gardner, Kansas, as well as in Corporate Woods in Overland Park, Kansas. I have with me today in studio Sophia Kandt, who happens to be my daughter and partner attorney, back for another episode of this. So welcome, Sophia.
Thank you. Excited to be back.
Today's topic we're going to talk about today is what happens if you become incapacitated, but you don't have a plan in place.
Yeah. This is, I think, an important topic for everybody. It's not something that is just important to seniors and elderly people. It's something that's important to children who are age 18 and above, really. Bringing it back to, this is for everybody. Imagine if you are a parent and your child has just graduated high school and now they're going off to college. They're age 18, 19, and they're off at college, and you get that call in the middle of the night that something's happened to your child and they're in a hospital, they're incapacitated. And so you drive out there, you get there, and only for the doctors to stop you and say, I'm sorry, I can't share information with you. And I can't even allow you to make decisions, as far as what happens to your child. And, in that situation, right, this is why this is for everybody. That doesn't happen often, thank goodness. But those are times when that does happen. That's a big deal and impactful for, the entire family. So having this conversation is important for those people, as well as for the senior individuals as well. If we've had experiences before, and we've had clients before where husband and wife, something happens to one of the spouses, and they think just because they're married that they have access to each other's healthcare information, they can make decisions on their behalf. And so something happens to that spouse, and they're in that same exact situation. So again, this is something that is so vital to talk about, have a conversation, make decisions for everybody.
Yeah, it's one of those that I think people, they just think about estate planning as it's for when we get older, even though we know it's not. But where a lot of people aren't thinking, they're getting their kids ready to send off to college. It's a big move. The kids are moving to this next season of life, and we've planned everything out. But we didn't think about what happens if tragedy strikes and they, are injured, illness, whatever the case is. Do you have the documents in place to be able to make decisions? Because once our children turn age 18, someone hits age 18, at least in Kansas, Missouri, where we're located, that's age of majority.
Right.
And as a parent, you don't have the authority to make decisions on their behalf anymore unless they've appointed you to make those decisions. Right. And you don't even have the ability to receive medical information anymore unless they've given HIPAA authorization for it to be released to you. So, as you said, luckily that doesn't happen that frequently, but, auto accidents, other types of accidents, we've seen it with just illnesses, that come in, and it is a very, very stressful, tragic situation. Right. And there's things we can do, but it's a lot of stress on the parents. And so we just want people to be thinking ahead. In our firm, we like to do what we call the move away package for, when the kids turn 18, to say, hey, let's get these in place. They don't need a real complex plan. We always tell people, don't overcomplicate this stuff. Keep it simple. But, basic documents in place at a minimum, the healthcare power of attorney, the HIPAA authorization, and I think a simple financial power of attorney would be the three that we look at as being essential documents going in place.
Yeah. So I think, again, this is something that is important to have that conversation about and be thinking through and get something in place. But, what happens if you do become incapacitated? you go, right, we talked about you go to the hospital, they can't share that information with you, you can't make those decisions. Well, what's your next step? You've gone through now this traumatic experience. Your spouse is in the hospital. You don't know what's going on. And during COVID, that was a time where you were stopped before you even got to into the hospital, and they stopped you there and said, because they weren't just letting anybody in. And so we had a client who wife was in the yard, I believe, and she was doing some yard work, and she had an accident. Something happened, and she had to be taken by ambulance to the hospital. And at the hospital, right, this is during COVID time, so they stopped. The husband came along, drove up behind the ambulance, and then got to the hospital. And they said, okay, we can't let you in because it's, we are keeping people out. But why don't you share with me your HIPAA authorization to allow me to share information about your spouse? And then he had to say, well, I don't have that. And what was that next step? You're dealing with that. You don't know if your wife is alive or dead, if she's going to make it, what's going on, is she being cared for? I mean, I'm assuming she's being cared for, but what's happening? So then you got to come, and now you got to meet with an attorney. What if it's a Friday evening? What if it's over the weekend? You are in an emergency.
Yeah. I remember that case very, very clearly. It was in the spring of 2020, and COVID, had just kind of this thing we're all trying to adjust to this new world that happened under COVID and lockdowns. It was a couple out in the yard and all that. And it was a tragic situation. Fortunately, the husband was under a tremendous amount of stress, and the social worker said, look, I can't share this information with you. I can't even tell you about your wife, what her situation is, because I don't have authority. She hasn't given any HIPAA authorization for me to do so. You're going to need to see an attorney. So he reached out to our office. I remember this so clearly. We were able, it was late in the afternoon at this point, but we were able to file for emergency orders. And by the next morning, we had emergency orders in place. But I was thinking about the stress and the burden that husband was under, not knowing what was going on. Because a simple document of a HIPAA authorization wasn't in place. And certainly we wanted more than that. Healthcare power of attorney wasn't in place. But the court appointed him to make decisions on behalf of wife. But as you said, it can happen to anybody, right? It's once we turn 18, having these things in place. Right. So if I think we have to go, when do these documents come into play? Right. And it's at our incapacity, right? Because as long as we have capacity, well, we can give those authorizations. We can say, oh, yeah, you can release information to mom and dad, or you can release information to my spouse or my children, whoever you want. Right. Healthcare professionals are going to look to you to make your own healthcare decisions as long as you're able. If you're able to make financial decisions, you're probably making your own, but if you wanted to appoint somebody, you could still do so. So it really comes down to, if you become incapacitated, if you're not able to give those authorizations, you've done the stuff in advance through the various legal documents that we tell people all the time. Everybody ought to have these things in place. Right. So I think this warrants a discussion about what is incapacity? What does that mean? And kind of looking at it from a legal sense, because it can have a little bit different at least determinations of what's incapacity in the legal world versus the medical world. Right.
And so there is that difference in, maybe a doctor has said, they've done some different evaluations, and they say, we see this oftentimes when someone has dementia, the doctor's going to say, well, they don't have capacity to make decisions or live on their own. They don't have capacity to, do a lot of those things. That's from the doctor, the medical side. And that is different from a legal standpoint. You've got to have testamentary capacity, really, is what you have to sign legal documents. And that bar is pretty low to have testamentary capacity. You've got to know generally, who you are, who people are, what assets you have. It doesn't even, we don't even have to have very specific details. I've heard some people say, one attorney used a phrase that essentially if they can fog a mirror, they've got enough legal capacity to sign documents. So, there's a little bit more to it than that, right? But I think that hits home that capacity level required to sign documents is pretty low. So even if we are in these situations where we've got dementia, we've got signs of dementia already, and maybe even we have that doctor's letter that says, no, mom doesn't have capacity anymore. That's coming from that medical side. She may still have legal capacity to execute and make these decisions, to appoint somebody else then to make decisions on her behalf.
Yeah, it goes in and I know when, somebody makes that comment, oh, foggy mirror, well, it's certainly more than that, right? You have to be alive. That portion is true. But yeah, in the legal world, the way as attorneys we look at it, I tell people it's a spectrum. Right? And the high end of this spectrum for legal capacity is contractual capacity. You have the mental capacity to make high-level decisions, to understand, executory contracts, understand long-term consequences of decisions that come in. That'd be a contractual capacity. On the low end of the spectrum is what we have, as you said, the testamentary capacity, the ability to create a will, to create testamentary documents. And it is a pretty low-level bar. Somebody may not have contractual capacity. They may, contractual capacity may require that you be able to remember certain things. You remember what you did and go in. Testamentary capacity doesn't necessarily require that. It requires that at the moment you're signing, did you understand? And what you have to have an understanding of, a basic understanding of your assets, right? What you own, what you hold, not a specific understanding, a basic understanding. And to be able to identify, your family members, your natural, family that comes in. And that's really about it if we boil down to what it is. Can they do that? And, it could be a situation where, you come in at 5 o'clock one evening and no, they don't have that capacity. They're confused. They can't seem to give you enough information to pass that. But at 10 o'clock the next morning, they do.
Right. And that's what a question I'm always asking people, too, is when I'm meeting with the family and they're concerned about that mom or dad, grandma, grandpa, whoever that is losing capacity quick. And I ask those questions. When do they have the most clarity? And typically that looks like the morning time is when they first wake up and maybe they've had their breakfast, and that's the time that they do have that most clarity moment of the day. And that's when we want to go and meet with them. I met with a client previously who she had doctor's letters, and the doctor in very great detail had said that she has dementia, and she does not she's got severe dementia, I think is the way that the doctor had, or severe cognitive impairment, I think is the way that the doctor said that, and said because she cannot recall what she did previously. She's got memory issues, and significant. When I met with her, because I needed to verify that she had the ability to amend her trust, amend her plan, choose, who was going to manage everything for her if she couldn't anymore. And she was able to, she knew who her children were, she knew where she lived, she knew what she had. She was incredibly intelligent, and she gets the ability to make those decisions. So just because you've got dementia and a doctor is saying, well, you don't have the capacity anymore, doesn't take away your right of who you are as a human being, and you still have the power to make decisions on your behalf. So I think that's a point that a lot of people, they don't understand that difference. So it's important to talk about.
It is. And, we could take this into a whole nother level of why we like to do our annual review meetings with our clients, and we're looking in and evaluating capacity and legal competency. But, it's one of those that don't assume it's too late, we can't do anything. See a qualified estate planning and or elder law attorney that can help you do that. And certainly at our firm, we make those determinations. Usually the determination, we want to make sure an attorney's making that determination as to whether or not they have legal capacity to sign whatever the documents are.
Right.
And various documents can have different levels of capacity that's required.
Right.
So always seek that professional help. Don't just make the assumption that it's too late to do anything.
Right.
So let's talk about that, because I think this is an important thing and discussion we want to have with our clients often. How do we determine, let's say you've done the planning, right? When we're doing a planning, there's this decision that has to be made on certain documents is to basically, when do you turn over the keys, right? When do you turn over control to somebody else? Are you just going to say, hey, I'm going to appoint my spouse or I'm going to appoint my children and I'm going to make their power to make these decisions on my behalf immediate? They can make them now. Or is it what we call a springing power, where it's only in the event of certain things? I'll make my own decisions, but my daughter can make these decisions on my behalf if I'm incapacitated. Okay, great. How do we know if you're incapacitated? You get to choose. Well, I'm incapacitated when, two doctors in writing have independently made the decision I am. That's what we see the standard, right?
Pretty much everybody who comes in, they say that they've got a power of attorney in place. We look at that. That is the standard, almost no deviation from that at all.
Yep. It'll say I'm incapacitated when, in the opinion of two licensed physicians who have certified in writing, I'm, do not no longer have the capacity to make decisions on my own. I'm deemed incapacitated. I'm also deemed incapacitated if a court of competent jurisdiction makes the finding. And so that's the standard language.
What does that look like when now you are in a situation where you have questionable capacity, but now your family has to drag you to two doctors, and oftentimes what's enough, you have enough capacity to know what's going on. You now have to go to two different doctors appointments. I've seen the wait time to get in some doctors as well. It can be a while. So now you've got to wait while you've got some outstanding bills to be paid, decisions to be made, and now they've got to drag you again to two different doctors. One that you've maybe been meeting with regularly, your primary doctor, but then another doctor who's now just evaluating you for the first time, or you have to go and have a court decide, and now you've got to get a court hearing. That is difficult. And if you know what's going on, are you going to be the first one to say, yep, get me in the car, let's go, let's start going to these doctor's appointments so that they can determine I'm incapacitated? They're going to fight, right? And oftentimes we see that it's not as easy as it sounds.
Well, and I think, and even, another concern is, what if you truly are incapacitated? Can't participate. We need to get in there. We're in crisis mode, but nobody can act because we've got to wait for you to be examined by two different doctors, wait for them to, write the letters that go in. So, can we make this better? And so what I talk to clients, make one decision would be, well, rather than saying this power only comes into play, upon your incapacity, what if we just made it effective immediately, right? If you don't have the ability to make decisions, your kids or whoever it is you're appointed have the ability to make decisions on your behalf. And let's just give them the power immediately. We don't even necessarily have to tell them it was immediate. Just say, hey, kids, you're my power of attorney. If I can't make decisions, the document's with my attorney, or you'll find it in the lockbox where it is. And when they get it, they're like, oh, we can act.
And why wouldn't you want, if you trust your child or whoever you've appointed in your document to make these big decisions on your behalf. I mean, they're right. The power of attorneys should be pretty comprehensive because you don't know what's going to happen in the future. You don't know what it is that they're going to need to do. So you're giving them pretty expansive powers. And if you don't trust them to make good decisions while you have capacity, why are you even naming them? Because if you have capacity, and what happens if you get sick, right? Going back to COVID times, you get sick and you're stuck in the house in quarantine and you can't leave, or you break your leg, or for whatever reason like that, you can't get out of the house, you can't go, you need somebody to help. Well, you're not incapacitated. If you don't trust them then to make good decisions on your behalf, don't appoint them. But if they do go and they do make the wrong decision, you don't agree with how they manage your affairs, you still have capacity and you can still revoke them. But if you've waited until now, somebody's determined that you are incapacitated, you've gone through, even if you've decided how to do that, you're incapacitated, now they mismanage your money and they do things that you wouldn't have really approved of, you can't revoke it at that point, right? I mean,
you're already incapacitated.
You're right.
So those are discussions we like to have with clients. When do we make this thing effective? Let's not just follow the standard language necessarily that everybody does. I'm incapacitated, and in the opinion of two licensed physicians, blah, blah, blah. So, okay, we'll make the determination. Maybe we make it effective immediately. And so, again, like you're saying, if we're going to give them the power to make these decisions when we don't know what's going on anymore, maybe we trust them to make the decisions. If we are one, just tell them, don't use this power till then. And but some clients still aren't comfortable with that. So we say, okay, what are some other ways? Because I want you, again, to think through, we may be in crisis mode. We need to move quickly. And if we use the standard language, it's not, effective until 2 doctors have written their letters. We're often waiting. It can take weeks to get this done. And we may need to move quickly, but we can't. So I said, okay, if you're not comfortable giving power immediately, what if we consider creating our own private disability panel? I'm incapacitated when, in the opinion of my spouse and my children, they unanimously agree that I have the power, or the majority of them agree. Or I could even say the majority of them agree, but my spouse, if living, has to be part of that majority. You can involve, your attorney, if my attorney is part of this disability panel. Again, there's no right or wrong answer. But the advantage of having this private disability panel is they can move much quicker. We're not waiting for the examinations to get in to see the doctor. In today's world, it can take a while, as you said, to get in, and then we're waiting for them to write their letters on top of that. So, again, there's no cookie-cutter recipe to any of this stuff. But good planning just requires us to think through, what does this look like if I get to that point and I'm going to need this? And I want people to make informed decisions, and you do as well. Just here's your options you have. What makes the most sense for you? And I find for a lot of clients, it's, no, I trust them, so I'm going to make it immediate. If not, then that private disability panel is probably my favorite. We can still include the other ways. You can have multiple ways. I'm incapacitated, if my disability panel says I am. If not, I could also be determined incapacitated by 2 licensed physicians in the court of competent jurisdiction, and my whereabouts are unknown. You can come up with multiple ways. But having that decision and making an informed decision that makes sense, but the idea is you want these documents to work when you need them. And so we need to move quickly often. So go ahead.
And a point that I want to make, kind of based on what you said, is I've seen a lot of healthcare power of attorneys. They come in and they're, that 2 doctor must determine, and it's a cookie cutter thing. You go online to these different websites, you download the healthcare power of attorney, and you don't really get to make a lot of options, right? You don't really even know there's a lot of options. So you sign the document, you do that, you go forward. But the time that you find out that they don't actually work the way that you want it to work is when you actually need them to work. So now that you're dependent on them and you have no other option, they don't work. Well, I mean, you do have another option, and that's kind of why we're on this topic. What do you do if you don't have anything in place and you're incapacitated?
And that's generally going to be, now we're relying on the courts. And the courts have a system there. And so if we're still alive, but unable to make decisions ourselves, we can go to court. Specifically, it's through the probate court, through what are called guardianship and conservatorship proceedings. So somebody, typically a family member, or, some trusted, close friend, family member, is going to realize that they can't make decisions on your behalf. They can't find, or there were no documents that appoint anybody, and they've run into issues. They're unable to make decisions, whether it's we can't get information about your health care. Nobody's appointed to make decisions about health care. Nobody can access the bank accounts and the financial things, whatever it is, because if you didn't appoint somebody, if you didn't do planning, you can't do it yourself, nobody has that authority. So to make those decisions on your behalf. So you're going to find out very quickly, or they're going to find out, families going to figure out that they need to go to court to get an order, because the banks are going to tell them, sorry, can't do it. The doctors, whoever, you can't make those decisions. And so they're going to go to court. And usually that means they're going to have to hire an attorney through guardianship and conservatorship proceedings. Guardian is the person or people that are appointed to take care of you as a person, to make healthcare decisions, make sure you're properly clothed, you have proper living conditions. They're making those kind of decisions, just like we're guardians for our children when they're young. Well, now somebody's appointed to make those decisions on your behalf. The conservator is the person or people that are appointed to manage your money, your finances, your property. Now, most often, the same person is appointed to play both of those roles, right?
Yeah.
To be both conservator and guardian. So, scenario I like to explain this with is, we've got a husband and wife. They're married. Wife just assumes that if something happens to the husband, that she'll be able to make decisions and vice versa. And then the husband goes on his bungee jump and bumps his head and he can't make decisions anymore, or he had a stroke, or he developed dementia, Alzheimer's, and they didn't do any planning. Certain things, wife's going to be able to make those decisions, right? On jointly owned property, their joint checking account. Well, she has the authority to, write checks and make deposits, make withdrawals, other joint accounts, she'll do things. If they need to sell the home just because you own it jointly and the husband's still alive, not going to be able to sell the home now with that. But there's other things, the assets, the IRAs, those are individual retirement accounts, individual being the operative word. And this is true for IRAs, 401ks, 403bs, all those kind of things. Retirement accounts, those are held in individual capacity. There is no joint tenant, so that's not going to help us there. Dealing with Social Security Administration, things like that where you don't have the authority. So wife's going to figure out very quickly that she can't do certain things and that she's going to have to get a court involved. So let's assume it's wife that goes to the court and she files to be appointed as both guardian and conservator. Before the court's going to appoint her, the court first has to make a determination as to whether or not the husband truly needs somebody appointed. Just because wife says so doesn't mean the court says, oh, yeah, here you go. So wife probably has an attorney represented her, has petitioned the court, asking the court to appoint her as guardian conservator, and make a finding that the husband is in need of someone being appointed. So the court's going to appoint an attorney to represent husband, unless there's already one representative. So now we got two attorneys involved because the same attorney can't represent wife and husband in this situation. So we've got another attorney involved to represent husband's interests. There's going to be medical examinations that have to be undertaken. And if the court makes the determination that, in fact, husband does need to have somebody appointed as both guardian conservator, now husband is considered a ward of the state. And the court will grant, this guardianship and conservatorship. Maybe there's been some temporary orders in place up to that point. But now, after the hearing is appointed, and the wife is now going to have to file annual accountings, annual reports with the court every year because, to make sure that she's properly using and reporting the assets of this now ward of the state. Something that could have easily been avoided with simple documents of powers of attorneys. But if we don't do the planning, the state has a plan in place for us, but it's going through the court system, but it is more complicated, it's more expensive.
So much more expensive.
And what's the number one thing we hear why people do estate planning?
They don't want to be a burden on their family.
And if we don't do the planning, and it comes to that. So hopefully we live out all our days here on earth able to make decisions on our own, fully competent. But as we know, that's frequently not the case. Right? Frequently not the case. We start to lose capacity over time. And so where you get to choose and appoint those people to make those decisions on your behalf. So let's transition to how do we do that? What's that process?
So that's where, we did talk about there's some online documents that we see people come in all the time, and, they're not state specific. They don't really provide the powers that are required under your state. Each state has different requirements, such as I know one of the things that you brought up earlier was the house, right? You have to specifically have the power, your spouse has to have a very specific power to sell the house in Kansas, and it's got to have a lot of information to it. It's got to have the legal description. It's got to have a lot. And so those online power of attorneys that you find, they don't have those. They don't really allow you the option to make all these decisions. So, that's where an attorney comes in play, and that's where we can really help make sure that you have the right documents in place, that they work, they're valid in your state, that you've thought through all of these different issues, concerns. The documents that you need, one is a durable financial power of attorney, general durable power of attorney. You'll see property power of attorney. There's lots of different terms for that. But what that is a document that you appoint somebody to make financial decisions if you no longer can make that decision. So and not just financial decisions. They can, file taxes on your behalf, apply for government benefits on your behalf, apply for Medicaid. They can help protect your assets from Medicaid spend down. And then, so there's this document. And then there's also a document that's called a healthcare power of attorney. And I think that's, speaks for itself what that document is. And what it is, though, is it's a document where you are appointing someone to now make healthcare decisions on your behalf. So what we talked about previously, thinking through, how do we want to name, who do we want to name when we create these documents, something that we need to be thinking through. And typically what we see with a healthcare power of attorney, right, is someone just appoints, one person and then the next person. And sometimes maybe there's a third person, but not often, right? Usually those online forms is just one name and then the second name. But there's a lot more we can do. And it's a discussion that needs to be had. Who are you going to appoint in those documents? There's also a document, and I think maybe we'll go into that a little bit more at some point on this podcast. But another document that is very important to have to avoid fighting court involvement is a living will. That's that document that is essentially a pull the plug document where if you are in that persistent vegetative state, or two doctors have certified that you are dying, you are not going to recover from this illness, you are saying, hey, I want comfort care. Don't do any unnecessary surgeries. Don't prolong my dying. And so you get to make those decisions in that document. Avoid court involvement. You don't need to go to the court to figure out what do we do in this situation. Mom and husband now are fighting over what happens to you in that situation. You've got to document and make those decisions now. Another document that I think a lot of people don't think is an estate planning document is that HIPAA authorization. And I know we talk about this a lot because it's so important. The HIPAA authorization, that's a document that says, hey, here's the people that get access to my healthcare information. Doesn't necessarily mean they get to make any decisions, but they get access to your healthcare information. And that's where you can name your spouse, right? If that husband we talked about earlier, he goes to the hospital during COVID, and if he had that HIPAA authorization, they say, great, here's what's going on with your wife. She's okay. She's, here's the issues we have. But without that, they can't share that information. This is where, naming your children. Maybe your children are younger. They're not going to make those decisions. But just thinking that through. So that's another document that I think is very important to have to prevent you from being, involved in the legal system in court if you become incapacitated.
Yeah, these are vital disability planning documents, especially if we don't have a trust. You and I are both big believers in trust. We are not attorneys who believe everybody needs a trust, but trusts are powerful disability planning vehicles that can help a lot of this. Wills, by their very nature, for people who have a will-based plan, wills do nothing for us while alive. They're not going to provide any disability or incapacity protections. They only come to play at death. So these documents that you talked about, the powers of attorneys, the living will, the HIPAA authorizations, this is our disability plan. It is vital to have in place. It's what's going to keep us out of court, where we get to choose who makes the decisions rather than somebody wearing a black robe, right? A judge making those determinations. We've appointed the person or people. And, we always tell people, let's think this through. What does it look like? Who's making the decisions? We don't have the crystal ball to know what's going on in their life at the time. And so there's a lot of determinations can be made of helping you pick who the right person or people are to make those decisions. But oftentimes people are not thinking this through, at least in our view. They're not thinking through, what does this look like when we get to the point we need this? Have we really thought this through well? And good planning requires that we just make informed decisions, right? Don't overcomplicate this stuff. Keep it simple. But let's think through, who we're going to put on this and how they're going to make decisions. How is the incapacity determined? All those things we've already talked about. They're coming in. And so a lot of those, you brought up these do-it-yourself, which we see lots of, right? In today's world with AI and technology where it's at, people can go online and they create these documents. We're seeing a huge increase. Financial advisors who said, well, why do attorneys have the market on estate planning? We're going to get involved here, and so they're using. In fact, I talked to one the other day that was doing a workshop, and who said, oh yeah, we use digital documents is the way she described it. We help our clients put digital documents in place. So she was doing a workshop on estate planning, and not an attorney, had no attorney there at the meeting with her. It just says we just use digital documents, and we have attorneys around the country that can help do this. Well, are those documents adequate? Have we thought this through? Because we see in these documents, they're not state specific. You mentioned Kansas has some very specific rules when it comes to power of attorneys. These are governed by state law. So in Kansas, if you're going to give somebody the ability to sell your home that is your primary residence, because our homes are homestead protected under the Kansas Constitution, the laws with powers of attorneys require very specific requirement that property be included in the power of attorney, including the legal description to that property.
If you have a spouse, your spouse has to sign, in addition to that, a consenting to that specific power in that power of attorney as well.
Yep, and so that's a Kansas law requirement that we see these forms often don't have, and even seeing with general practitioners who are not estate planners who often leave that out. But other powers, back when I first started doing this, truly, the general durable power of attorney was a general power of attorney. All these specific powers were not necessarily required. Now, the homestead's one of those that's required. I want to say that was something entered in the Kansas law back in 2002, as I recall. But most, there's other things that most states have little variations on this, but the power to gift, the power to create trust, the power to do asset protection planning, do the Medicaid planning, those are powers you have to specifically grant. And these do-it-yourselfers are the ones that are not being created by estate plan and elder law attorneys. Most often don't include these. They're back to the general powers of attorneys. And when we're doing this, are we thinking it through? So, it's not to say that those documents are good. A lot of those documents can be very, very good. It's just they're not going to do certain things, and maybe that wasn't important to you. But we just want people to think this through. And so I tell people, hey, if you've created one of these, bring it out. Let us take a look at this and go in. And maybe it works just fine for your situation, but you just want to make sure before we get to the point where now we're reliant on it and that it did what you needed to do, which was part of what we like to do. Every client we have, we want them to be part of our annual review process where we're going to look at this stuff and we're just confirming plan choices. Here's who you named to make financial decisions. Here's who you named to make healthcare decisions. Here's who you named as your beneficiaries. This is still the way you want it. But look at that, make sure there's not been any changes in the law, anything that would invalidate those powers of attorneys. And so, certainly the financial power of attorney, we want to update it at least every few years. We like to update it annually. I just want fresh ink on the signature line. But with all these documents, healthcare too, are there changes in the family dynamics? Are there changes in law? Have there been, maybe there's been divorces. The person you named is no longer appropriate. They've moved away.
They've had children. They're now busy. They've got so much going on in their life. They've got a new job. There's so many things that do change in life with yourself and your family that it requires that you revisit this, right? Estate planning is not a transaction. It is not a one and done. You've got the documents in place and now go on and never look at them again. When you do that, laws change, people change, everything changes. It requires that you review it. And maybe you don't need to update it, but maybe you do.
Yeah, at least every few years look at it. But we come in. So, okay, just to kind of recap what we talked about. If you do not do any planning and you become incapacitated, the states have an answer for it. It's going to be state specific, but the courts are going to be the answer through guardianship and conservatorship because you're still alive. You're just incapacitated. And somebody's going to petition the court on your behalf to make decisions to be appointed to make decisions on your behalf. How do we avoid that? Through documents like the financial power of attorney, healthcare power of attorney, the living will, and the HIPAA authorization. So key, vital disability planning documents. Easy to do. Just make sure that you think this stuff through. You're appointing the right person or people, and you review them on a regular basis and determine when they become effective. Is it immediate? Is it only upon incapacity? If so, how do we determine that incapacity? So all decisions we would say, that people should be making. And, for those listeners who have not made those decisions or have not reviewed yours in a period of time, whether it's coming to us at Stockton Kandt, we would be honored to talk with you and help you figure out these decisions. But you want to seek the advice of a competent estate planning and elder law attorney. All right, so we're kind of at the end. Anything more you want to add, Sophia, before we wrap up here? All right, so I would just encourage listeners, like and subscribe to this podcast. Our goal is to bring you relevant, useful information that you can implement into your plan to not be a burden to your loved ones, to make sure that things move quickly. You will find information presented in this podcast. It is published on YouTube, Spotify, Apple Podcasts. So look for us there. You'll also find it on our website at stocktonlaw.com. So until next time, have a great rest of your day.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.